Good morning.
Okay.
Okay, I'll go ahead and call to order this hearing of March 12th, 2026 in the matter of Z0496-25, application by Astra Solar. My name is Joe Turner. I am the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so you understand how you can participate in the hearing. I start by saying I'm not a county employee. I am licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting an independent review of the application before me today. My role as the hearings officer is to conduct public hearings and make decisions about certain matters, land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of Commissioners to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to this application. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are available on the county's website. I will note that staff are not the project proponent. They are merely providing an overview of the project and the laws and their opinion as to whether or not the approval criteria are met or not. The applicant, once staff has presented their staff report, the applicant, who is the proponent, will have the opportunity to present their proposal and respond to the staff report. Then, if anybody else wants to testify in support of the application, they may do so. And then anybody who wants to testify in opposition or with questions or concerns. That should cover everybody who wants to say something about this application. You'll fall into one of those categories. Once everyone has had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing without taking any further public testimony. In most cases, I'll issue a final written decision within about 2 weeks after the close of the record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. If you decide you don't need to testify but want to receive a copy of my decision, you can contact staff and they'll put you on the mailing list as well. Excuse me. Anyone with an interest in this application may offer relevant oral or written testimony, but testimony should be relevant to the applicable approval criteria, which are set out in the staff report. There is no arbitrary limit to how long you can testify, but your testimony should be relevant to those criteria. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. It's not a popularity contest, so whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria. Um, Sorry, I lost my train of thought there. It is important that, oh, no, I said that. The but it is important that you make your best case to me. My decisions are final for purposes of the county that may be appealed to the Land Use Board of Appeals or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that people can understand what the issue is. If the applicant wants to object to any conditions of approval on constitutional grounds, they must raise those issues before me as well. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. If anybody wants me to, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. If anybody else wants me to hold the record open for any other purpose or to continue the hearing, you must make that request before the close of the hearing today. Also, my decisions are subject to state law that requires that I issue a final written decision within 150 days after the application was filed. So there's some limit to how long I can continue the hearing or hold the record open. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. Most people's names appear on my screen, so that makes it easier, but not everybody. If you represent someone else, please say so. And that concludes my introduction. Staff will give us an overview of the Zoom process itself. Ms. Fields.
Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members' cameras will not be turned on at any time. The audience members' microphones will be muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will use the raise hand button. For people who have called in to join by phone, you can press *9 to raise your hand. Staff will call upon you when it is time for you to provide testimony. You will unmute your microphone and then provide your name and mailing address when you begin. Once you have provided your testimony, you can lower your hand and your microphone will be muted again. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you can email the testimony to myself, Joy Fields, at jfields@clackamas.us, or mail it to the Clackamas County Planning and Zoning Office at 150 Beaver Creek Road, Oregon City, Oregon, 97045. My email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive written notice of the hearings officer's decision and a link to access the full written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by emailing it to me at jfields@clackamas.us. These instructions are also included on slide 2 of my PowerPoint.
Your PowerPoint hasn't been up. Was it intended to be?
It was not. You have not requested me to start my PowerPoint yet.
Oh, okay. Whenever you want to start that.
Okay. It would be helpful to have slide 2 up as I'm reading the instructions. But as Hearings Officer Turner mentioned, we are here today for the hearing for Z0496-25. I'm so used to writing 26 now that you may find that I accidentally referred to it as Z0496-26. So if that happens, I apologize. As I just went over, this hearing is being recorded. Audience members will not have their videos turned on. Public testimony is at a specified time, and if you wish to provide testimony, please raise your hand so that we know you want to provide testimony. Before you begin your testimony, please state your name and mailing address and lower your hand when you're finished. My email is jfields@clackamas.us. The land use application before us is for a solar facility on tax lot 700 of tax map for Township 4S Range 4E Section 08. The property has address 25205 South Metzler Park Road. It is zoned exclusive farm use. You'll see in the staff report that I provide a range of acreage. That is because the tax office identifies it as just over 60 acres and the applicant identifies it as 59 acres. Staff did not find that that acre difference made any difference to the analysis that was completed. The proposal is to construct 12 acres of photovoltaic solar generation facility with solar panels, racking, inverters, overhead poles and lines, and perimeter fencing. Public comments received to date have included comments concerned with the loss of farmland, noise, fire, the character of the area, visual impact, inconsistency with the comp plan, and we have received comments from the Transportation and Engineering program regarding site distance, driveway access, and roads. In the staff report, I recommended denial for a few reasons that I'll go through. Those reasons are highlighted in the site plan on this slide in red. In the northeast corner, there is an area proposed for solar arrays on high-value farmland. Down here along Southeast Metzler Road, there appears to be solar arrays within the 30-foot setback. As indicated by the Transportation and Engineering program, site distance has to be retained for this access drive along the western portion of the property. And so the fence will need to be moved back, and thus the solar arrays may need to be modified. The red box on the western side is to highlight what may be discrepancy in the site plan regarding distances. There was no scale bar. And so I used the 12-foot driveway width to measure the distances and the 20 by 20-foot parking area down here to again estimate the distances from the property boundary to the solar arrays. There is a setback exception for ground mounted solar facilities that are less than 6 feet tall. The structures do not have a side or rear setback. The proposed location is not near the rear of the property, but it is near the western side of the property. In addition to setback concerns and soil concerns, staff had concerns about farm impacts. Since my staff report, there have been additional testimony received that highlights the impact of noise on the pigs that are a farm commodity in a neighboring farm. There's also more concern about fire, as well as visual and character impacts. This is an aerial image that shows the existing hay or wheat field, and on that field, the general location of the solar facility is outlined. I think this is a great aerial image to show the workings of the farm currently and the placement of the solar facility. Exhibit 8 was testimony in opposition, but it included a picture. And as they say, a picture is worth 1,000 words. And so, as I talk about the farm and forest impacts test, or that the concern over impacts to surrounding farm use, I wanted to include this picture. Um, I did generally talk about impacts from noise and fire being a concern. There's also a concern of removing 12 acres of currently farmed field. And what would that do to the farming community? That is addressed in the staff report. Setbacks I addressed with the site plan. Front setbacks do have to be met by solar arrays, and there is concern about front setbacks not currently being met. Section 401 of our zoning code is the section that covers exclusive farm use, and solar generating facilities are identified as a conditional use in that zone. The conditional use is subject to the Oregon Administrative Rules, 660, Division 33, Chapter 38 specifically talks about solar facilities. I have Chapter 20 up on the screen because it's the definitions in that Oregon Administrative Rules. That includes the definition of high-value farmland. The site plan or the soil analysis conducted by the applicant included an assessment of the soils, and you'll see in the image on my screen. I have a question for you. Can you see the thumbnails of the people on my screen? Or do you just see the soils image?
The, the attendees and panelists, you mean?
Yes,
Yes.
you do see them.
Yes.
I don't know how to minimize. There we go. Um,
I take it you weren't seeing them.
I was,
Oh,
but I wasn't sure if it was hiding the soil map.
no, I'm seeing the soil map just fine.
Perfect. The soil map is important because it highlights the prime soils located in the northeast corner of the proposed solar facility. High value farmland is defined as irrigated and classified prime, unique, class 1 or class 2 soils, or non-irrigated, classified prime, unique, class 1 or class 2 soils. The spring water soils that have the classification of 80B are considered prime soils, and therefore this corner is considered prime soils. That has bearing later on that I'll touch on. The Oregon Administrative Rules also requires that if the solar facility is proposed on high value farmland, that it's limited to 12 acres. And this proposal is limited to 12 acres of solar generating photovoltaic facilities. In addition, the Oregon Administrative Rules wants the solar facility to limit impact to farming on the site. The applicant indicated that the location down in the northwest corner of the site would allow the other areas to continue being used for farmland. Staff agree that the location is such that the other areas can still be used for farming if the property owner chooses to. The Oregon Administrative Rules make sure that soil erosion, construction and maintenance, and weed mitigation is considered by these facilities. And the applicant provided a soil erosion and compaction study that recommended that the construction and maintenance of the facilities be done during dry soil conditions. They provided a weed mitigation plan that identified ways to mitigate the potential introduction of weeds to this farming community. And so as conditioned, those pieces of the Oregon administrative rules could be met. However, there is a provision that solar generating facilities cannot be located on the high value soils listed in OAR 660-33-28A. And that is the high value definition that includes prime, unique, or class 1 or class 2 soils. And F says that if you're impacting those soils, then you have to show why it's not feasible for you to modify your plan. The applicant did not indicate why it's not feasible to remove the impact to the soils classified as 80B by installing the solar arrays down here close to Southeast Metzler Road. And so staff found that that criterion was not met. In addition to the underlying zoning standards for setbacks and uses, the application is also a conditional use. And because it's identified in section 401 as a conditional use, it can be reviewed as a conditional use application. Staff found that the site was overall suitable. It has soils that are not classified as prime. The environmental overlays that are subject to the section 700s are more than 500 feet from the proposed site for the solar facility, meaning that the waterways identified on the statewide planning or statewide wetland inventory are more than 500 feet from the project location. And the topography was such that it seemed like a suitable site for solar. 1203 requires that the conditional use meets the concurrency standards in 1007-07 for transportation. Unmanned utility facilities are exempt from concurrency. And because this facility is generating power and transporting that power to the grid, it meets the definition of a utility facility. And because there's no staff working out of the site, it is an unmanned utility facility by definition, and therefore it is exempt from 1007-07. 1203 does require that the proposal complies with the comprehensive plan, goals, and policies. The applicant identifies that our comp plan encourages alternative energy sources, and it does. And being in the EFU agricultural designation means that it has to comply with feasible conditions of approval to make it less impactful to the community. And so we are reviewing this land use application for compliance with our zoning code, and thus it meets the land use chapter goals and policies for agricultural land. There are no specific standards in Section 800 that apply to solar generation facilities, but because it is a utility facility, it is classified as an institutional use and subject to several of the 1000s that I'll talk about in a minute. One of the biggest criteria in ZDO 1203 for conditional uses to meet is that the proposed use does not substantially limit, impair, or preclude the use of surrounding properties for the primary uses. Um, as noted, there was a bit of testimony received this week after the staff report went out that indicates that the noise from the facility could substantially limit or impair their ability to raise the coon pigs um, at, because of the noise. So that should be looked at. That was not fully addressed in the staff report. The testimony does identify a few ways that they could modify their own property to deal with the noise, but that would limit their farm use based on the testimony provided. Um,
The pig farmer, not this site farmer. Is that
correct,
okay?
correct. The pig farmer identified that they would likely have to install evergreen trees and wood fencing to try to muffle the noise um, if this is approved.
Right.
And that the noise they are concerned with impacting their livestock. Looking at the 1000s, 1002 applies. It is the protection of natural features. As I noted, the natural features of concern that are addressed in 1002 include streams and river corridors. It also includes it includes steep slopes, deer and elk winter range, fire hazards. All of those are addressed in the application sufficiently, and staff found that there was no um, that this criteria could be met. Um, in 1003, hazards to safety address mass movement hazards, which are not identified in the proposed location of this development and thus not applicable. 1004 deals with historic protection, and there's no known historic landmarks on the property or immediately adjacent to the property that would be impacted by the proposal. 1005 is site and building design. There's no buildings proposed, although the solar arrays meet the definition of structure and thus have to meet the setbacks. There's no buildings and the site is not open to the public. And so many of the sections of 1005 are not applicable. However, the transportation and engineering program is also the surface water management, and 1005 touches on ways to make the site design compatible with the intent of our comprehensive plan. And the 1200C permit that the transportation and engineering program identified as being required because of the ground disturbance area that will occur because of the solar facility. With that permit, 1005 is met. 1006 also addresses surface water management, and that 1200C permit is a stormwater permit that addresses surface water. The applicant also identified ways of dealing with solar or soil erosion in their application sufficiently to find that as conditioned, as recommended in the conditions, this criteria could be met. 1007 is roads and connectivity. In this section, items to be aware of is the proposal is not proposing any public roads or new roads. Um, it is proposing an access drive through the facility that will have to meet the roadway standards and have turnouts for fire every 400 feet. The South Metzler Park Road is identified as a future bikeway, and currently the right-of-way does not meet the requirement for the functional classification of the road. And thus to facilitate the future bikeway and to meet the cross section of the road that is required by 1007 right-of-way dedication along that border with South Metzler Park Road is recommended as a condition of approval. Additionally, the site distance for the adjacent access drive is currently blocked by their proposal. And so modification of the fence in the southwest corner would be needed. Either it would need to be moved back or you would need to be able to see through that corner to see if any cars are coming so that people leaving the adjacent access can exit their driveway safely. Um, for all of those surface water management, access road, driveway, all of those road related items, the Transportation and Engineering Program identified that they have a permit called a development permit that will be required for all of these improvements. So with those conditions, 1007 could be met. 1009 was landscaping, and that property being over 59 acres in size and having only 12 acres being the proposed development, there is sufficient landscaping on site, trees, existing landscaping, and the fence that the applicant is proposing is a site obscuring fence that will shield the parking area from the public road. And so staff found that 1009 was met. In the application, the applicant identified that signage regarding voltage may be placed to ensure safety of people, but that no monument signs were proposed and no signs other than the required warning signs would be installed. So 1010 was found to be not applicable to the application, but if a sign is proposed in the future, it would have to meet 1010 requirements. 1011, section 1011 is open space and parks, and based on the proposed location being located in an area that had less than 16% slope and it not being in an area identified as open space on the comp plan map, 1011 was found to not be applicable. As I mentioned, parking and loading would need to meet the roadway standards and development standards of transportation and engineering. That ensures that 1015 is met. 1015 does require parking. The applicant is proposing a parking area just behind the gate at the driveway. And for unmanned utility facilities, having one parking space for the staff that come to monitor and do maintenance is sufficient. The applicant identified that no solid waste or recycling would be generated by the proposed use, and so staff found that 1021 was not applicable. With that, staff recommended denial because there were items that were not met. But if the hearings officer finds that those are sufficiently met, there are proposed recommended conditions of approval for you to consider.
Thank you, Ms. Fields. You noted that solar facilities less than 6 feet are not subject to side and rear yard setbacks. I assume they are less than 6 feet.
That would be a good question for the applicant.
Okay.
They did not provide elevations showing the height of the facility,
Okay.
of the solar arrays.
Where are we with the 150-day clock on this one?
Um, the decision has to be issued by July 4th. July
Okay.
4th is um a holiday.
So the
The
third.
following business day is July 6th.
Okay. How is the fifth not? What day is it a weekend by any chance?
Yes.
Okay.
Exactly.
Okay.
July 5th is a Sunday.
Okay. I'm dealing with another appeal in a different jurisdiction that those kind of issues are very critical, but here it's not going to be. We got plenty of time. Um, you addressed that one. So on page 20, I just had a clarification question about the citation.
Hmm.
It,
Page 20.
yeah, right in the middle of the first, the finding in the middle of the page talks about subsection, paragraph H, small h, capital A, and on the page before that, the code lists capital H, one through small letter Roman numeral, I guess 1 through 5, and then it lists small I, which I think should be a capital I, and then A, B, C. So is that reference to H, A, B, and D, C, and D? Should that be I, or is it H, I? This is really confusing.
It is when you're dealing with Oregon administrative rules, they're yeah, IV.
So,
I think you are correct. That
okay.
little no, because the H is little.
H is capitalized on page 18. I is lowercase on
But
page 19.
G and H um are
Look at
little.
the OAR. I remember I had to basically print it out and reformat it because it is terribly formatted on the state's website. Not a critical issue. I'll check it out and figure it out.
Yes, I don't know off the top of my head. I
Okay,
think
thanks.
that is little I specifically because it's little I,
Okay,
following little h and little g.
okay, thanks.
Mm.
On page 9, the last paragraph before these criteria are not met talks about concern about additional impervious surface
Oh, oh yes. Uh,
could go ahead.
Impervious surface. Thinking about solar arrays being hard
Oh
and
yeah, I can see that
surface.
they're impervious surface. I just questioned that wouldn't the surface permitting they had to get a permit? Wouldn't that address that issue?
It probably would, but I didn't have that in front of me, so I didn't
Okay.
know where the water will flow and if it will impact surrounding farmland.
Okay. That's what I needed. Um Generally on 6 or 6, I think it's 16. Let me find the right page here. Oh, maybe it's 6. I just formatting question. It's not okay. Some of your findings are italicized, some are not. And I just, is that intentional or just a,
If the findings include a quote or a specific section of the code, then it's intentional for it to be italicized.
okay,
If, however, it is not a quote, then it may be a formatting issue. Like
okay,
on chapter 16, the subject property is a tract composed predominantly of soils. That is my finding that is not copied from anywhere because there's no quotes around it. That is a remnant of the italics above.
Okay. The site distance issue with the fence.
Hmm.
Fence isn't required, so theoretically they could eliminate the fence and resolve that part of the site distance issue.
Theoretically.
Okay. But
However,
there
the
may be,
concerns from the neighbors wanted us to make the requirement of the 8-foot fence a requirement to reduce impact to surrounding neighbors. Um, and so I would be concerned with eliminating the fence altogether, but you're
Mhm.
right, it's not technically required.
It
Um,
would raise other issues. I understand.
of glare and yeah.
Okay. It's an 8-foot fence. Is it subject to setback, especially the front yard setback?
Fences are not.
Really? Most jurisdictions, again, these probably are urban jurisdictions, have, I think it's 42 inches in the front yard for sight
Right.
distance, but it
Right.
doesn't, but excuse me, fences are exempt from,
And yes. And um that is why the condition of approval is there to modify the fence so that the site distance for the adjacent driveway is
right.
there because it's nowhere else. Yeah.
Okay. Um, I think that was it. That was the only questions I had. Thank you. Thank you, Ms. Field. Is the applicant's opportunity to testify, Mr. Pearson?
Thank you, Mr. Turner. My name's Ken Pearson. I'm an attorney with Schwabe Williamson and Wyatt, representing the applicant, Astra Solar. My address is 1211 Southwest Fifth Avenue, Suite 1900, Portland, Oregon. Thank you to the Clackamas County staff, particularly Joy Field, putting this together, development engineer, John Alderman for his engineering work on this. I know it's a lot of time and effort to put these together, generally on pretty short order ahead of these. I'll be taking the beginning of this presentation, and then Spencer Wallace, the representative who is with the applicant, will be doing maybe the bulk of the presentation, or at least the technical parts of the presentation. Uh, the first issue I'm going to address is the constitutional issues with the right-of-way dedication condition. It's probably no surprise. And then also the legal discussion related to the various criteria that the staff has found were not met, with some of those being reserved, the more technical ones being reserved for Spencer to hit. So just starting with the right-of-way dedication, I mean, this is sort of a textbook extraction with no individualized finding. Um, it's a 10-foot right-of-way dedication to expand the 40-foot right-of-way. Engineering noted that the lack of additional traffic from the right-of-way dedication meant, or sorry, the lack of additional traffic from the project meant that a right-of-way dedication was not appropriate. That's their facts and findings number 3. It sounds like the county staff, in an attempt to apply the county code universally, uh, more or less disregarded that to require it. But, under the Sheets v. County of El Dorado Supreme Court case in 2024, that clarified that the typical Nolan-Dolan protections will apply regardless of whether that's a case-specific adjudication or general legislative code like we have with the county roadway standards. So, I mean, under this recent Supreme Court precedent going back 40 years, that that is a Fifth Amendment violation, without having some sort of individualized finding. And certainly, no additional traffic is not mitigated by additional bike lane. Like, those two are not proportional or really even connected at all. So I won't beat a dead horse there unless you have any questions. I'll go ahead and move on to some of the condition 9C, which was a requirement to revise the site plan to show a vehicle washing station. So we agree with condition 4 requiring compliance with the weed mitigation plan, but the weed mitigation plan only requires a wash station during the construction phase. So it's not a permanent wash station. And where that's at, it's going to move, but that's required under the 1200C permit anyway. And so we think it's premature to determine where the wash station should be. And then it's also, again, not a permanent fixture. So it wouldn't make sense to put it in the site plan for the entire project. I think the next issue I wanted to discuss was the loss of farm product as an argument for the farm impacts test. That's a novel argument. I haven't seen that one before, that taking 12 acres of hay out of production will then make hay so expensive that nearby farms can't operate. But in any case, that is not what the farm impact test looks at. The farm impact doesn't look at market impacts. It looks at or it doesn't look at the market impacts of not producing. It looks at the impacts of the use itself. And that's both clear in the legislation itself, where it refers to the use causes a significant change. But also the examples provided in the code: traffic, water availability, introduction of weeds and pests, damage to crops, litter, trespass, the stuff that we've all seen get litigated before. None of that includes how the price of hay might change. The landowner could at any point choose not to continue growing hay, and that would be, and even go into another farm use, whatever. So specifically, just looking at kind of recent LUBA cases, we've got Curie v. Douglas County 2020 that points to the fact that the test is limited to actual impacts on specific surrounding uses.
What was the name of that case?
It's Curry v.
Oh,
Douglas
Curry.
County.
Thank you. Curry.
IE, actually.
Oh, thank you.
And
That
that's
helps if I spell it right.
81 Oregon LUBA 602 from 2020.
Thanks.
And so it's got to be these specific impacts on specific surrounding uses. And again, this sort of generalized impacts of having 12 acres of less hay in this one area is not the kind of impacts. And just thinking of the public policy there, the legislature has already determined how much farmland is too much farmland to take out of use, and that's 12 acres at a time on high value farmland, 48 acres within a 1 mile radius. There is no other solar project within a mile of this proposed project. So looking at or trying to consider the market impacts, besides being speculative and really a pretty difficult thing to determine, would just really just undermine the state's policy on and the county's comprehensive code policy of encouraging renewable growth or renewable energy within certain limits. The next discussion was on the surface permeability. That was another area that we disagree that the solar panels are going to cause any unique issues with water runoff. For one, they're not it's not like a carport where it's a continuous impermeable surface that pushes all the water to the edge of the property. The water moves no more than 6.5 feet, half the width of the solar panel, before it dumps off the side and hits the same permeable surface that was there before. So we noted in our site plan that the only newly created impermeable surfaces are some small concrete pads for equipment and the steel piles that are actually holding up the solar panels. And and our soil erosion control and compaction plan addresses this. I mean, that whole point of that plan is to minimize the compaction, maintain the permeability of the surface. There's significant space even between, I think it's 13 feet maybe, between the solar rows of solar panels. So there isn't any there isn't any meaningful, significantly new impermeable surfaces that would be driving the water off. And as you mentioned, the future permitting is also going to require us to the development permits are going to require us to avoid any runoff during the construction phase as well. So ultimately we don't see that as being a criteria that we've failed to meet. I think that is all that I'm addressing. Some of the other technical questions involving the noise that was raised, involving the nearby, I say nearby, it looks like it's about 775 feet away, pig farm, and other issues Spencer's going to address, as well as just giving an overview of the project. So with that, Spencer, I will, well, actually, sorry, Mr. Turner, I'll give you a chance if you have any questions for me.
I don't have at this point. Thank you, Mr. Pearson.
Okay, thank you. Spencer, go ahead and if you can pull up your presentation and get started.
Yeah. Hello, everybody. My name is Spencer Wallace. I am with Conifer Energy Partners, representing the applicant Astra Solar. My address is PO Box 1585, Everett, Washington 98206. Yeah, today we are talking about Astra Solar and a little bit about the project. We are proposing a 12-acre photovoltaic solar power generation facility, and we also proposed perimeter wood fencing. A little bit on the project. The project will occupy 12 acres of the roughly 60-acre parcel, and it will be 3 megawatts AC interconnect, which has the equivalent energy production to power roughly 450 homes. And that energy will flow back onto the local grid, onto the Portland General Electric, and will service commercial and residential customers. I would like to speak a little bit to the considerations on siting the facility in relation to the entire parcel. When looking at parcels and figuring out where to site the facility, we take into consideration soil classification, the topography, access for both construction and long-term operation and maintenance, as well as following the county and state code to maintain long-term, farming and not to fragment the field in any way. We also consider the requests of the landowner and how they would best like to continue farming operations should they choose to. This is the submitted site plan showing the facility in the southwest corner of the property. It was cited here so to give as to not create, a long access road that through the property, as well as not leave any fragmented portions of field. And that's why it does abut the property lines while also maintaining proper setbacks. Additionally, on the property, the landowner undertakes other farm activity, has a dwelling and farm buildings. So we, at the request, give that sufficient space so that he can continue those activities that he would like to. In regards to soils, the facility is on the 80C and currently a small portion on 80B. And as you can see here, there's another portion of 80C soil that we stayed off of because it is also slopes to the north and would disrupt farming activity. Here is a visualization of the topography of the area of the parcel itself. The facility would be sited on the rightmost portion of this photograph, and placing the solar facility best operates facing in a southward direction to generate power. Alternatively, placing the facility anywhere else on the property would decrease just the operability of the facility. Yeah. We are taking into consideration staff's finding and removing panels from
I'm sorry,
the
Mr. Wallace, could you go back for just a sec? I just want to orient myself on your aerial photo.
yeah.
I didn't realize I'd muted myself. Is the road, Metzler Park Road, is that to the right of this photo?
Correct.
Okay, thank you. That just wanted to make sure I was seeing this correctly. Go ahead.
Yeah,
Were you-
there are additionally the cardinal directions.
Right, but I was just trying to combine the two
Yeah, of course.
in
Yeah,
my head.
it's to the on the right.
Okay,
Mhm.
thank you.
Yeah, let me back up to soil slide. Yeah, I just wanted to say that we are going to comply with the current staff's condition and remove any panels cited on 80B.
Okay.
And yeah, to speak to the construction of these facilities, they are very relatively simple, benign facilities made up of three main parts: the racking, panels, and inverters. The racking is made up of steel piles that will be driven into the ground. No concrete is necessary for that. Those hold up the panels, which then collect the energy, and the inverters then transform that energy into power that can be used by the grid. And overall, again, to reiterate on the comment about permittability or the so water impervious surfaces. Yeah, while the only a small portion of the entire 12 acres will be impervious, and that includes both the posts, cross sections, as well as the small concrete pads.
How are the panels themselves not impervious?
Because they are mounted above ground, and so the actual the ground area that
Okay, ground
can
beneath will still
accept,
be,
yeah,
okay,
can accept the rainfall
okay.
does not change significantly. Yeah, and the soil compaction plan also addresses that.
Sure.
Yeah, to speak to the benefits of a facility like this, the facility will create roughly 45 skilled trade jobs, as well as make the local grid more robust by adding local power generation instead of having power transmitted, over the mountains via large transmission lines. It just helps balance out the load in the local area, and then that can also help lower the need for future upgrades. Additionally, there's quite a bit of financial investment to create a facility like this, and also helps diversify the farm income, so that other farming activities can be financially feasible. To speak to energy generation as a whole in Oregon, there's a good portion of the energy comes from fossil fuels, and that only increases in drought years as the hydropower is not available. Building more solar power generation diversifies the energy stack. Over the last few years, Oregon has fallen from 22nd in the nation for total solar installed, and that's primarily because of public policies that have made it difficult for solar to get sited and installed. Thank you, and if there are any questions on the presentation, I would be happy to answer them.
Thank you, Mr. Wallace. The only question I had was the height of the panels. If they're less than 6 feet, they're not subject to setback. Are they more than 6 feet? It appears
Roughly
from
7
photos
feet.
there. Pardon?
Roughly 7 feet.
Okay, thank you. That's the only question I had. Thank you. Is that it from the applicant then? Okay.
Um, One moment.
Okay, no problem.
Hi there, Mr. Hearings Officer.
Go ahead. Can I get your name and address and then your testimony? You're muted, sir. We're not hearing you. We were, but they went away.
Can you hear me now?
Yep. Gotcha.
My name is Jonathan Nelson with the applicant, Astra Solar, address PO Box 1585, Everett, Washington 98206. I just wanted to step in here to address a couple of the issues from the staff report and then also some of the comments. First, in regards to noise, that was addressed in one of the sets of comments and with concerns as it may relate to an existing farming activity. We do address noise in our application, both in our burden of proof and in Exhibit B or Exhibit A, I'm sorry. Exhibit A is our, I guess, internal title of it on the exhibit list. I guess, yeah. Our materials are all under Exhibit 2. But in our burden of proof, we address noise in relation to OAR 340-035-0035. And that OER provides some noise regulations and standards for industry and commerce. And uh, our finding there that OER is not relevant to the EFU solar siting rules, but we added it in there to just address the issue of noise. And the big takeaway is that the noise ratings from or the noise sources from these facilities, they come from the inverters, and those noise levels are all less than the most stringent levels in uh, noise standards in existing OARs. And the point source of that noise is from the inverters, which are usually situated in the center of the facility. So if they're in the center, there's all the panels and racking radiating out from there that is basically effectively obstructing and dampening any noise that would be coming from those, plus the fence, which in this instance, we're using a wood slatted fence. And so to give sort of some comparison or context, like the noise levels from these facilities is comparable or even less than like noise from a residential air conditioning unit. Um, and so we think that, you know, we think noise is not an issue from these facilities because of that. And then also, if you consider um, other types of uses in the EFU district or timber district um, from existing farming or just other things that can occur on those parcels, there's lots of other things that would produce noise much louder than that. Um, some of them are like mass gatherings up to 3,000 people, uh, hunting and fishing. Um, Operations and exploration for geothermal oil and natural gas and mineral resources and farm and forest uses as well. So that's in the burn proof and our Exhibit A supplemental document. And then with regards to impermeability or impervious surfaces, also want to point out that in the staff report, staff agrees with our finding. One of our findings regarding this that it's page 26. The bottom of page 26, there's a statement that staff agrees with the applicant's finding that there appear to be slopes of approximately 16% of the subject parcel, but not within the development area. In the second sentence here, the proposed use is not grading, stripping vegetation, or covering the lot by structures and impervious surfaces. So just wanted to point out alignment on that as well. While the panels, each individual panel, the water is going to hit that and run off onto bare ground that we're not disturbing. And so there's no like point source increase in runoff because the panels are installed throughout the facility. It's not one continuous or contiguous array. There's rows of them. Um, and yeah, so we don't believe that is going to be an issue with this site. It hasn't come up as issues on other prior sites either. I think yeah, on the whole, I think staff's conditions, the recommended conditions of approval, if approved, for the most part, aside from what we've addressed and what Mr. Pearson has addressed, we can live with those, and we think that um, that adequately addresses relevant decision criteria for this facility in a similar manner as other prior facilities. Um, so I think, yeah, I can leave it at that for the time being.
Okay. Thank you, Mr. Nelson. Is there anybody else who'd like to testify in support of this application? If so, please click on the raise your hand button now. Janelle Asplund, I hope I'm pronouncing that right. You don't need to unmute yourself.
Yes, thank
There
you.
we go. Now we're hearing you.
Hi, my name is Janella Asplund. I live at 25300 South Metzler Park Road, So I live directly across from where the applicant, the farmer in question, conducts the majority of his farm operations. I live two houses down from where the proposed solar array is going in. I'm in support of the project. You'll have to excuse me. I have a tremor in my vocal cords, so that's why
No problem.
I sound a little wobbly. So just let me know if you can't understand me. So thanks for giving me the time to speak. Some of what I want to talk about is support of the particular kind of project that's going in. And some of what I want to talk about is support of the particular farmer who's applying for the project. So I think we've heard some concerns from the neighbors about protecting the character, the visual impact of the land, the rural quality of our area, which I think we've all moved out to Estacada, or we all live in Estacada on purpose because we appreciate the lifestyle and the landscape of this area. I think we have to acknowledge that farming in America is in many ways an industry under enormous pressure and increasing hardship for those who do it. The farmer in question is a man who is well past retirement age and who is working long hours. I'm in the particular position of no one else on the road to see him as he's going about his business late into the evening and early every morning, working on his farm. So I know the hours he's putting in. He's also the only person on our road who relies solely on his farm property for his income. So I think that's worth noting that everyone else, particularly, I believe, all of those who may have raised issues with their farm, make off farm income. He does not. I want to point out that according to the USDA, 2024 marked the largest recorded year-to-year decrease in net farm income of about 25%. So someone who's relying on their farm to earn an income is now looking at a 25% decrease in their ability to do so as of last year, right? Last 5 years, between 2017 and 2022, 141,000 farms in the US shut down. So people worry about the loss of American farming. We're seeing it. This person is trying to protect his farm. He's trying to keep his farm. It's been in his family since his grandfather's time, and he's trying to protect it for his daughter, his grandsons, his nieces and nephews. And this is part of how he's doing it and trying to protect his family legacy. I think trying to stand in the way of that for someone who deserves to be retired at his age is unconscionable, frankly. I think insisting that he farm it in hay is increasingly naive given the amount of labor involved, and particularly now that we are looking at war in the Middle East and looking at the cost of gas, fertilizer, oil rising, the cost to farm, the cost to hay is going up and up and up. So the actual expense of maintaining that field in hay, however lovely it is becoming untenable. So I think we're doing a real disservice to an actual farmer trying to make an actual income on his property by insisting that he do it in a way that adheres to our aesthetic value more than it adheres to his financial value. I think we also have to look at, and Spencer, you touched on this a little bit, of the fact that what he's doing, what he's proposing, is actually a public service to all of us, right? We've all seen our energy bills go up. We've all seen the costs of our electric bills rise and rise and rise to the point where they're starting to become absurd. We know that PGE raised our rates 20% in 2024, another 5% in 2025.
Ms. Athlon, you don't need to go into all these specifics.
Okay.
I understand the cost issue.
Yeah, I think it's important though to note that what he's doing is trying to raise an income for himself, but he's
I
also
understand.
doing a public service for all of us, right? That this isn't simply something he's doing for himself, but it's also something that benefits all of us, and that he's moving us forward in terms of how we raise electricity that serves our families, our households, our state, that adheres to state mandates
I
in terms
understand.
of Oregon's renewable energy and the mix that PGE provides. So I do want to offer that. I'd like to also address a couple things that Mrs. Fields brought up, that
Okay.
the photo she showed of the driveway, the neighbor down the road.
Mhm.
I would want to point out that that person's house has absolutely no windows that face the solar field. So yes, while that driveway points in the direction of the solar field, there are no windows of their house that look at the solar field. And there is, in fact, a hill out that side of their property that would prevent any visual interference of the solar field. I think as it goes to raising livestock in the area, many of us have hobby farms on this road. Many of us raise animals on this road. We also have Christmas tree farms on this road that are harvested by helicopter, which is considerably louder than any solar farm or the construction of a solar farm would ever be. So I think that concern, while relevant, is unfortunately well outweighed by some of the farming activities that already happen on this road. So ultimately, I would ask you, sir, and the rest of the neighbors who object to this activity to consider the actual farmer in question, the fact that he helps many of us maintain our own properties and conducts haying for a whole number of us, such that we are able to maintain our farm properties. And that this notion, this ideal of what a farm should look like, that it should be a green, empty field, maybe dotted with cows, shouldn't
Okay.
outweigh how he makes an income off his own farm, that a borrowed view of an empty field shouldn't
I understand
interfere.
you've made that point, Ms. Asplin. I'll ask you to move on.
Okay. I will actually close with some questions, which I'd like to have Spencer address. Could we talk a little bit about how long the farm will take to construct and the noise levels of that? And could you also address some of the fire concerns that people have had and take care of those questions too, please? I will conclude there. Thank you for giving me the option to speak.
Thank you, ma'am.
Mhm.
I'll give the applicant a chance to respond when after everybody else has testified so he can address everything at
Yes.
once, but
Yes, that's
I will
fine.
definitely
Thank
allow
you.
that.
Mhm.
Anybody, Ms. Asplin, if you click on the raise your hand button so we know you've had the opportunity to testify. Anybody want to testify in opposition or with questions or concerns? Anybody want to say anything about this? Please click on the raise your hand. There we go. Don Thompson. You'll need to unmute yourself, Mr. Thompson. There we go.
Good morning. Thanks everyone for providing this opportunity.
Mr. Thompson, we're barely hearing you. Could you move closer to your microphone?
Yeah, so I'll try to move this a little closer to me. Is that a little better?
Not really, no.
Not really. Okay.
I'm going to turn my volume up just so let's try that.
Okay.
That's better.
Okay, good. I can speak a little louder as well. I wanted to say, first of all, Don and Susan Thompson, we live at 25150 South Metzler Park Road. We are directly across from the southeast corner, southwest corner of the proposed location. The picture that was shown in Joy's, where she said it speaks 1,000 words, that's our driveway, which is 50 feet across the street from the driveway to our home is the driveway in that picture. It's 50 feet across the road from the solar array. And just to share with the listening audience, the front of our house, which is the front door and several windows, does look directly at the solar array as well. I do want to which is 175 feet away from the solar array, the proposed location of the solar array. I do want to mention that we are not opposed to renewable energy in any way, shape, or form. We think it's a critical part of our infrastructure for the entire United States and the rest of the world as well. However, we are somewhat concerned about the siting location of it because of the proximity to our front door and our driveway. But the driveway much less than the front door, obviously. And on the back side of our home, there are no windows that we're concerned about at this point, so that's not a concern. But the front door and the front windows are. We are also very concerned about, and we want to make sure that we have done everything possible from the county standpoint and from the installer standpoint and the Astra Solar about the blind hill that was brought up in our presentation that was given to the county. There is a hill that it's called the Hilltop House, which is on Don Smith's property, right across the street from Janelle. And right at that point, the reason it's called Hilltop is because that's a high point on the road to Metzler Park. And unfortunately, it's getting busier and busier as our communities grow and the popularity of the park. We estimate that there are somewhere around 2,500 people that come and go from that park with trucks and families and trailers and toys. And they come over the top of that at 55 miles an hour, maybe a little bit less. It's about 8 seconds to the proposed entry location from the top of the hill to that location. I really believe that we need to be sure that we do not underestimate the potential of that situation. It could cause great harm to people, equipment, most of all people, of course, because of an accident. And I realize that it's only temporary that we'll be using it, but the park opens for RV parking on May 1st and goes through September. And that's when the majority of those 2,500 RVs do come back and forth. We are concerned about it. All we're really asking for in relation to that is to make sure that there is a appropriate location for that driveway chosen. Don does have one towards the southeast corner. Which one is it? The southwest end. He has a driveway there that goes in, and he also has one on the actual farm itself that's way below that hill, so you don't have to crest over it and run into workers that are putting in the solar farm. And so there's a couple of options that might be better than that particular dangerous location that we'd like to bring to everybody's attention. Unfortunately, it's only about 350 feet from the crest of the hill to the proposed location. Another 350 feet further is our driveway, or the one corner of the proposed location.
And Mr. Thompson, just so I'm clear, the hill that you're talking about, that's to the west of the site?
That is correct.
Okay.
No, sorry, it's to the east of the site. It's up Metzler Park, east towards, let's call it Mount Hood from proposed gate opening.
Great, thanks.
And like I mentioned, it's only about 350 feet from the top of that hill to that location, which is our concern about that. And
the other that's why I'm questioning the other driveway options you noted. Aren't those closer to this hill then?
No, actually, the one that Don uses for his equipment is actually before the hill, so it's on the lower end.
Okay, so this hill is on it's on the frontage of this. It's on the section of Metzler that butts the site, correct?
Yes.
Okay, that helps. I was thinking it was off-site farther, but thank you, sir.
Yeah.
Go ahead.
The second one I mentioned, which is further down across the street from our driveway, another 350 feet further down, that's one that he uses to go in and out with his equipment when he's haying that property, and it's much safer. And I'm sure Don would attest to the fact that people drive like crazy on this road coming and going from the park, as well as people that live on the street. And and it's a 55-mile-an-hour street, unfortunately, because it's unposted presently for anything under that. So we want to make sure that we're taking that into consideration. That's the most important thing. The
Thank you, Mr.
second
Talbot.
thing
Oh,
is
go ahead. Go ahead.
Pardon me?
Go ahead. Go ahead.
Okay. The other one, the next one, besides road safety and the location to our front of our house, is alternative siting. We had proposed in our information the possibility of moving the location from being right in front of our house, right next to the neighbor's complete driveway in the front of her house, and really all of the people on the information we sent in showing their location and how many feet to the proposed solar array. Our concern is that we know that the 80C and the 80B soils are basically the same. They're spring water sand or spring water loam, but the only difference between those two designations, from what I can tell, is the amount of slope. One being closer to 15% maximum, the other one being closer to 8% maximum. I was just kind of wanting to know that with a 59-acre location, isn't it possible that we could slightly move this location? And we had asked for a 250-foot barrier between the property location on the west side, the southwest corner, which goes up K. Alexander's driveway, one of the residents that are right next to this location, for the entire length of that, which is really untenable for her to have to look out her front window at that much. Plus, it impacts our visibility out our front window as well. If we moved it east by 250 feet, it would come into the other 80C, 80B in a more significant way. That's true. But the only difference that I can tell, because it's the same soil, is the amount of slope. But these things are frequently roll over hills and dales and can be installed. So it would really make it much nicer, more tenable for everyone. I have drawn a drawing of that I sent in to Joy and the staff there that they could look at. So that's real important for us to make sure that we take a look at. With 59 acres, we hope that we can somehow come to a happy medium. I will completely agree that Don Smith is a hardworking, he's in my age category in the 70s, and he deserves as many breaks as we can give him. And this would help him, no doubt about it. It would help him and his family and preserve his ability to keep that property. No doubt about that. Janelle's right as well. So one of the questions I have for the team there is, had they ever looked at placing the array in any other location, and why did they specifically choose that location? Was it related to the soil only, or was it related to the cost of installation of it? All we want to do is move it 250 feet to the west towards the hill. It would make it easy to access from either of those alternative driveways I mentioned. So that's a question that we want to know. Why did they choose only that location? A second question that I would have is for, again, the people there is, did they, when they mention the fencing for it, we appreciate the fact, because generally these solar arrays do not put side obscuring fences around them. They put a 6-foot high chain link fence with 3 strands of barbed wire, and it's really an industrial look. This is certainly not an industrial area, but they were nice enough to say that they want to put a wood slatted fence. I'm not sure exactly. I did put a photograph of the type of fence I believe they meant, but I'm not sure, because they kind of oscillate between side obscuring wood slats, which indicates like a chain link fence with slats in it to obscure the vision, and or a wood fence where they have wooden pickets, let's say 1x5 or 1x6 fence board. I'm not sure which one they plan on putting in. Either one would be sufficient for us. However, the fact that they say we're going to build up to 8 foot, I would ask that we confirm, how tall is the fence going to be? Is it going to be 6 foot to the top of the side obscuring portion? or is it going to be 7 foot, or is it going to be 8 foot, or is it going to be 2 foot? That's just cynical there, that 2 foot part. But the point is it should be high enough that we don't have to look at the solar panels as much as we look at the fence itself, that it would be sight obscuring to those accessing the park and enjoying the feel of this area, as well as the neighbors. So that's a concern on our part as well. So that's basically everything that I have on my concern list. I'm just wanting to make sure that I understand why did that choice get made versus moving it just slightly to the east, so that we could all enjoy the least amount of problems associated with having to look at it out our windows or driving in and out of our properties, whatever the case may be. So from that, I think I'll give my time back over to anyone else, and I appreciate your guys' listening to us.
Thank you, Mr. Thompson. I'm going to take one moment. I just dropped my computer mouse, so I need to get back to the right screen.
Can I ask Don a question real quick?
Sure. Give me just 1 second. I had that little technical failure there. Go ahead.
In exhibit, Don, your comments are saved as exhibit 8. And in exhibit 8, you have a diagram that shows the top of the hill to the proposed gate as 700 feet. I'm going to share that real quick.
That'd be great.
In your testimony just now, you mentioned that it was 350 feet.
Yeah, good catch, Joy. And just yesterday, I'm assuming you can hear me. Just yesterday, yep. I decided to double check my notes on that. And I went out with a tape measure, although the wind was coming sideways and blowing it all over. It turns out the 700 foot was from the top of the hill to my driveway, not to the proposed gate opening. So it should have been 350 to the opening, 350 to my driveway. So that was an error in my part when I drew up that illustration for you.
Because I bring that up because the comments from engineering indicate that 610 feet would be the site distance needed. And so that does bring in concern if it's 350 feet, whether there would be enough site distance there.
Yeah, it is not 650 feet, at least from the top of the hill where we show a vehicle coming over it in some inset photos. It's actually 350 feet from the top of the hill down to the proposed location, and which is an appropriate location from the standpoint of easy access, no doubt about that, but in a dangerous location from our perspective. So we believe that it is 350 to the proposed location at this point in time.
Thank you, Mr. Thompson. Let me get my volume fixed. And Michelle Swain, looks like you're unmuted. I'm not hearing you yet, though.
Hello, can you hear me?
There we go. I'm hearing you. Yes, thank you.
Great. So my name is Michelle Swain. We live at 24810 as well as 24802 South Metzler Park Road. We're approximately 700 feet away from the proposed facility. We raise pigs and chickens on the property. And we are asking that the county deny the application. First, I just kind of want to just go over some points that we had. So of course, we already know that it was active farmland hay, and that was was being farmed by Don Smith. As far as our livestock go, they're pasture-based, they are outside. And we are concerned with the inverter noise, just any of the electrical infrastructure, the fencing, as well as the maintenance activity that will be on the property. We've also not talked about how long it will take to put this project in. as well as the noise that will be coming from that. I know that's going to be temporary, but of course, that is definitely a major concern for us. We have a type of pig called kuni kuni, which I know it sounds weird, but they have large ears and they have impeccable hearing. The road that it will be on, and by the way, when I was looking at the map, the actual inverters would be very close to the road. It wasn't showing as was stated that it would be in the middle. It shows the inverter actually being close to the road. So hopefully that can be addressed. But that is a corridor of noise for us. And we hear our kids, for example, when they're up there playing, we hear them way before we see them. It just flows through. So the question is, number one, for the noise, there was no comprehensive exam, or not even exam, but like just a comprehensive evaluation. We got no actual data as to what those inverters will produce. We got no actual data as to what the screening is going to be on the proposal. We got kind of like, hey, it would be like an air conditioner. And so we wanted to get the actual data from that. We wanted to know how many inverters were going to be there. If it was, let's say that one inverter sounds like one air conditioner. Okay, well, how about if 4 or 5 of them are there? So we wanted to get actual data from that. Let's see, for the noise, it is something that's very probable that would cost us money to remediate on our own property. So there's that. We do also have fire safety issues. And actually, let me go back. I would actually be for myself, Michelle Swaim, and my husband, Brian Swaim. And his more concerned was the fire safety with the fire marshal who put Sarah Poet, who put who went ahead and approved it. She also approved that conditional use with saying that wildfire should have some type of evaluation in this case, especially because we're a single egress, meaning that if, let's say, for example, the power facility had a fire and that touched the road, our family could not get out. So that would definitely be a fire concern for us, as well as just the hot Oregon summers. Something happens, let's say there's a fire that happens on the facility, and then we have a wildfire. I mean, this is going to be prime disaster for our family just to get out of the property. Going back to actually the soil map, I wanted to discuss as well. So, like Don Thompson said, that the spring water loom that we have there, you have the 8B and the 8C, and the difference is supposed to be the topography. What I have seen is let me go check this out. The actual proposal on page 10, which brings up the custom soil report, there's a warning on there, and it says that this soil map may not be valid at this scale. You guys can read that. That just kind of shows that there should be a soil evaluation and maybe even topography. I don't know if that could have been changed. I'm looking at this though, and when I see that warning before a report that's happening, especially on a 12-acre parcel, that may need to be something that is addressed. Leaving that, and even with the erosion prone, because those are erosion prone soils. I see that we have even with the report from the erosion, I adore it because he's the compaction, he's going to limitations. And again, this is a limitation. And he specifically is talking about erosion when it's dry versus erosion when it's wet. And that, what do we got? Compaction relief measures should be performed with methods that mitigate the mixing of topsoil with subsoil. So again, there you're mixing with the soil right there. The trenching, like all of these things, of course, are going to mess with the soil. I'd also go back to, there's going to be gravel put down in the facility, large gravel, and I just want to talk about the cleanup of that gravel as well, making sure that soil is put back to orderly place is what it was previously. So yes, and then so the decommissioning also is something that we wanted to talk about. On this form, it says that it will go down to at least 3 feet. I just want to kind of reiterate and ask the questions. Are you going to take everything, meaning the piles? Are you going to take, because those go down, and you said they're going to be down 8 feet. Is that going to be taken out? Any conduit that's buried more than 6 feet, is that going to be taken out? Is all that gravel, large pieces of gravel, we know that are can't go back into the soil to actually farm it when you have the type of gravel that is. What are we going to do with that? And I also wanted to address, actually going back to the helicopters and even what the applicants were talking about as far as noise on the property. That's why all of the noise pieces that the applicant said, I went back and I'm double checking, but all of those are also conditional use. Just like this is conditional use, those would go through the same procedures in order to figure out if that is the best fit for the land and what's around here already.
I don't think the helicopters are a conditional use for harvesting Christmas trees. I think that's
Yes, they are used for harvesting Christmas trees. It's actually pretty amazing.
yeah, but I don't think it's a conditional use. It's a permitted
Yeah,
use.
those are the only things. So, but
Okay.
I just wanted
The
to
other, I understand. Okay, so the
absolutely,
other
yeah,
things
yeah,
that they
yeah.
listed are conditional, which is,
Absolutely.
yeah.
Yeah, what was said is that they are in use and that would cause noise, but that's also cyclical, the nature of farming in general, right?
Right.
So that would only come when they're harvesting. I mean, as far as on this property, the major people that have the Christmas trees, let us know. It's amazing. So then I can go ahead and take care of my animals how I need to. So that's something that we've been able to mitigate, and it's not a constant. It's not a 24 hours, or it's not a 12-hour kind of thing. It's just a part of our cycle of living here and having the farm life. So that's definitely not a constant noise. Let me see. I think that, yeah, I think that pretty much hits our things. But again, I want to really talk about that decommissioning. I want to talk about the volume, the noise. I did look up on DEQ when they have industrial businesses going in, that they can only go up 10, I believe it is, for volume going up. So according to the ambient noise that's in the area, our ambient noise is about 25 to 30. So this is definitely going to be going way over ours. The applicants has already said it's between like 45 and 50. I understand that may be zoned there. Another question I would have for the county is, let's say, for example, in the summertime when these are in full effect and they're humming up a storm, is that if they go over this a certain noise level, is there any ramifications for that? Is there any way that we are able to monitor this? I did not see anything about the length and distance away. Like, I mean, it would be nice to have actual specifics. For example, if they have already facilities, why don't we have noise studies done on these facilities that are previously done so we can see that around the entire community? It would be nice to have that. I think that's about it right now. Are there any questions for me?
How do you spell your pigs, the breed?
Absolutely. Kune. Kune.
Coon.
Kune
Okay.
Kune. Yeah.
Kun, but it's Cooney.
It's Kune. So yes, correct. It's Kune.
Oh,
It's
N-E.
a,
Thank you.
yeah, it's a New Zealand breed.
Okay, but it's
So Kune.
Kune, Kune. I missed the E.
Correct.
Thank you.
Correct.
Thank you. That was the only question I had. Thank you, Ms. Swain.
Okay, sure.
Is anybody else who'd like to say anything about this application who hasn't had a chance to? And Ms. That would go, raise your hand, went away. I have an email, AJSARA, etc. I'm sure you know who you are. You need to unmute yourself.
Yes, sorry, I wasn't able to input.
No problem.
I'm Andrea Sirocco. We are at 24871 South Metzler Park Road. So our property is immediately adjacent to the proposed solar farm, separated
Can you
by,
spell your last name, ma'am? I missed that.
sure, it's S like Sam, ARACCO.
Thank you. And you're adjacent to the site on which direction? North, south,
We
west?
are to the west, if I
Okay.
have my directions correct. We're
If you're
separated
looking
by
at the photo, the aerial photo, it's west to be left. That helps. Fort
yes,
Park
that
is
is correct.
to the west, right? Okay, thank you. Go
Yep.
ahead.
Yep. Uh, Several of the concerns that we've got involve the single egress that Michelle brought up. After the 2020 fires, we were suddenly quite a bit more aware of how we would be impacted by any kind of a fire situation because there is only one way out of here. I've got horses, and if in a case like that, we've got to gather everything. We've got to gather animals, everything needed for the animals, and try to get out. If that road's blocked, or whether it's by fire or firefighting equipment, we're done. So that's a huge concern for us. The erosion and drainage is also a concern. We're downhill from that property, and I don't know how familiar you are with horses, but they can be a little sensitive on quite a few topics. And one of those is being in too much moisture for too much time. If that redirected water impacts our field, then that impacts the animals. We have a direct view, both inside and outside our home, of the property, and that is a different, separate concern. Property values are a concern. Reduction in property values, I should say. Huge impact. A lot of us have selected this area.
Mr. Rocco, I will say that the county code does not address property values. It's not something that's relevant to the approval criteria. The Land Use Board of Appeals has held that, so it's not something.
Okay. All right, I'll skip that. Another concern is the electromagnetic field generation from a solar farm of that nature. Horses are extremely sensitive to that. And, that it affects their, I would want to say their natural life. It affects their health. It affects their ability to, this may be more information than you want. Their digestive systems are very sensitive. And if they're under stress, they start to develop ulcers. And that's a concern.
Thank you, Mr. Rocco. Anything else you wanted to add?
Nope, not at this time.
Thank you, ma'am. Ms. Wayne, your hand's back up. Did you have something? Mr. Rocco, could you click on the raise your hand? There we go. And Ms. Swain, your hand is still up. Did you have something? Do you have a question?
Sorry about that. I had to get a permission to get it unmuted. Yeah, the one concern I did have is when we were talking about for our pigs, I didn't make the point, and yes, it is just an estimate, but the value in which we would have to remediate our property would just be astronomical for us. And so that would be, if it was fences, if it was not just evergreens, but some type of bush that would go up in order to try to alleviate that noise, especially the tonal noise that comes from inverters. So I just wanted to reiterate that it would do a cost for us in order to remediate our property.
Okay, thank you, Ms. Swain.
Thanks, Mr. Turner.
Anybody else want to say anything about this application? Not seeing any. Oh, Mr. Thompson.
Yes, thank you, Mr.
Let
Turner.
me turn my volume up again just a minute.
Okay, thank you.
Go ahead.
Okay, the question I have, Mr. Turner, is the testimony that we sent in with the exhibits. Do you get to look at those as well?
Yes,
Or
absolutely. I understand there's some has come in since the staff report, which I haven't seen, but I will review it before I make my decision. So I will review everything that has come in, and if I held the record open, anything that new that does come in.
okay, could I ask Joy, could you put up Exhibit E for me
Of your document.
of my documents?
Yeah.
Yes, sorry. Actually, that's not E.
That's D. He wanted E. One more.
There we go. That's the correct one.
And Mr. Thompson, you've testified about the 250-foot buffer, so I understand that. There's no reason to repeat that.
Yep, well, no need to. As you can see, the red line is the proposed location,
Mhm.
and the black line was a something that we'd love to try to work out with the landowner.
I understand. You clearly testified about that. There's no reason to go back into that.
And then the little circles are our property across the street, Mr. and Mrs. Sirocco that just testified. And up at the top of that picture, above the 250 foot, is Alexander's property that
Mhm.
looks pretty close to it. I just wanted to point that out, that we gave what we think is a reasonable alternative location that might be useful if we can determine that soil issue that I brought up. So I just wanted to
I
point that
understand.
out. But if you're going to
Thank
look at them, then you'll see what I'm talking about anyway.
Yeah. Thank you, Mr. Thompson.
You bet. Thank you.
Um, Anything further from any response from county staff, Ms. Fields?
The two concerns I would have about modifying the site plan as just recommended by Mr. Thompson is the continuity of the remaining farmland. Having a strip that's 250 feet down the western edge of the property may not be suitable for farming. I don't know because I'm not a farmer. However, I would be concerned with that. Also the soils, the prime soils. So those would be my two concerns about that, because it goes all the way north into the prime soils.
Yep.
Modifying it to go a little more east, with the avoidance of the prime soils would be fine. Down below, down by South Metzler Road, from a staff perspective. And that's all.
Okay. Thank you, Ms. Field. Applicant's response, Mr. Wallace and Mr. Pearson. Mr. Pearson looks like.
Thank you. I'll just kind of briefly hit on the aesthetics arguments. Though I totally understand and sympathize with the fact that some people don't like to look at solar panels, or don't like to look at a big fence blocking a solar panel. There, but that is, not a criteria. This is an allowed use. The sort of policy question has been made both at the county and the state level. So, again, not going to harp on this too much, but we did want to make sure we were on the record pointing out that that is not that is not a criteria. I think there are specific questions that were raised. Spencer's going to jump on and address those, but any other legal questions that you might have, I'd be happy to get back on.
Okay,
Yes.
I don't have any at this point. Mr. Wallace?
Yeah, first off, thank you for everybody testifying and providing comments. I would like to specifically address first Janelle's comments and questions regarding construction and fire concerns. First off, an estimate of construction timeline would be 4 to 6 months. Within that 4 to 6 months, the loudest portion of that would be for the pile driving, the supports for the racking. That would be conducted within a 2-week time period from 8 a.m. to 5 p.m. So very normal work hours. In regards to fire concerns, our site plan and proposal has been reviewed by the EFRD, the Estacada Rural Fire Department, and we do have a stamped site plan from them, and with their requests of a 12-foot clear area around the interior of the facility for a rural fuel break around the facility. Additionally, to address fire concerns, all these facilities are designed by electrical engineers and follow the strictest code to ensure any electrical faults. Also have controls and relays and emergency shutdown systems that would prevent that from further spreading. And additionally, we have to obtain an electrical permit from the county before construction. To address a few of Don's concerns regarding sightline and the chosen fence style, it is, to be more specific, a wood picket fence. And so something that's very typical around homes. And that would be more specifically 7 feet tall. And then around the sight lines, we note that in the staff report, a sight distance of 610 feet is noted. And according to our measurements, our access road will be able to meet that 610 foot sight line in both directions down South Metzler Park Road. And then thank you, Ms. Fields, for addressing the siting considerations for why the facility is where it is. To address Ms. Swain's comments and questions regarding decommissioning, the facility is required to decommission and remove all materials. That will include all buried conduit and the driven piles. Those will be pulled out, and so the entirety of the pile will be removed. And also the bulk gravel will also be removed so that the field can essentially be put back exactly how it is today, so that it can be farmed. See, and yeah, I guess to further address the noise, I believe we did note the actual the decibels and the location, the point source of a central location, and it will be no louder than any other, or it won't raise the underlying
Ambient noise level.
ambient noise. Yeah. And that's all I have for now.
The ambient noise, do you have any, is there something in the application that addresses that demonstrates that it won't increase the ambient noise?
We can submit additional comment.
Okay. If you want to do that, I'll need to hold the record open. Do you want me to hold the record open for that purpose?
Yes.
Okay. So what I would be predisposed to do is hold the record open for a week for anybody to submit new testimony and evidence. A second week for anybody to review and respond to whatever was submitted, and then the third week for the applicant's final argument, which the applicant can waive if they choose or submit early. Does that any issues with that?
Well, we would ask for a 3-week rebuttal period. The applicant has or 3-week response period. If we want to do like a 7/21/7, if that would be acceptable. We would, of course, waive the applicable time with the 150 deadline. The applicant's got some travel coming up, if that would be.
Okay, that makes sense. Yeah, no problem then. So you want me to hold up for a week for anybody to submit new testimony and evidence, 3 weeks because of your travel issue, anybody to respond, including the public, and then a week for the applicant's final argument?
That's correct. Yes,
Okay.
sir.
Okay. That works for me.
Is 1 week enough time to get a noise study?
Good question. I wasn't sure if that was their plan, but it might be because you just need more time to accommodate the vacation rather than actually respond. You might be better to stack the additional time during the first period.
Hi there, can you hear me?
Yes.
Okay. So we wanted open record to more fully review some of the comments that just came in yesterday.
Yeah, no problem.
And then also to address comments that came up during the hearing. Yeah, so
do you want more time at the start in case you want to prepare any studies or documentation rather than a 3-week response? That would I would accommodate the vacation issue, and it would give you more time to submit or to prepare documents.
Yeah, I guess if we could have a 3-week response or rebuttal period to public comment, that would be.
Well, if you want to submit, so when you say there's 2 response and rebuttal periods, I'm going to hold it open for anybody to submit new testimony and evidence. So that would be your opportunity to respond to what's been submitted and the testimony today. Then the second week is only responses to whatever was submitted during that first open record period. So if nobody talks about noise has been raised, so you'd need to address noise, for example, during that first open record. So it might be more appropriate to have a 3-week or 2-week initial open record, and then a 1-week or 2-week response.
Okay.
2-2-1.
Yeah, we could do 2-week open record, 2-week
That works.
response.
Okay. Let's do that.
So 14/14/7.
Yes.
Yeah.
I'll grab a calendar. I'll give everybody specific dates. Mr. Thompson, I see your raised hand. I'm not going to take further public testimony. Everybody's had the chance to testify. You will have the opportunity to submit additional written testimony during the open record period, which I will go into in just a moment. Sorry, I lost my train of thought. Let me grab my calendar. Oh, the 150-day clock. I think it's July 4th. That was it. So I think we're okay. Let me look at this. Actually, Mr. Pearson said he would extend it. Let's go ahead and extend it for this 5-week, no, 5-week open record. If you'd submit something in writing during the first open record period saying you're willing to hold the clock for that open record period, I'd appreciate
I think
that.
we would prefer to just toll it for the additional time that we asked for, if that is enough time for the county staff. So for the
Aren't you
extra,
asking for 5 weeks? 2 weeks, 2 weeks, and a week?
Um, over the 7, 7, and 7, I think we were asking for 2 additional weeks.
But if, oh, okay, we have plenty of time. So, okay,
Okay,
if you'll
and
hold it
if
for
we need
two
more
weeks,
time,
that gives
we're
us
very
plenty of
happy.
time. I'm
Yeah,
not
happy to do
worried.
it if we need more time. Absolutely.
I have a vacation coming up in somewhere in there. I don't know that we're going to get to it, to, if that's going to conflict or not, until I start looking at my calendar here. So, what I'm going to do is hold it open. Today's the 12th. So I'll hold it open for 2 weeks until March 26th at 4 o'clock for anybody to submit additional written testimony and evidence. So anybody can raise any issues during that first 2 weeks, but anything anybody wants to submit has to be physically received. Ms. Fields,
Due to my vacation, I will not be able to get it into Acela until that following Monday.
the 30th.
Correct.
Okay. So what I would do is just start the second 2 weeks from that following Monday. So let me, since we're not doing I got to write down what I'm going to do. Okay, so I'll hold it up until the 26th of March at 4 p.m. for anybody to submit new testimony and evidence on any issues. The county will post that by Monday afternoon, March 30th. So the second 2 week period will go until April 13th, Monday, April 13th. Oops, March, not April. 13. For anybody to respond to whatever was submitted during that first period. The second open record period is limited to responses to whatever was submitted during the first period, so no new issues can be raised at that point. And then for final week until April 20th for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, or submit their final argument early. I'll close the record upon receipt of a request to do so, or their final argument or the expiration of that deadline. So Monday, the 27th is the last day for the applicant alone to submit a final written argument. Again, anything during any of these open records has to be physically received by the county by 4 p.m. I will do my best to get my decision out by May 11th. I go on vacation the next week, at the end of that week. So I'll do my best to get it out before I leave. I'll let the county know if I don't get to it. I don't see a significant issue, but I've had some more difficult cases this year that have put me behind on other things, so it could happen again. That's what I'm going to do. I will send my decision to the county. The county will send it to parties of record. So anybody who testified orally or in writing or who does so during the subsequent open record period will be sure and receive a copy of my decision when it's issued. That concludes our hearing. Thank you all. Have a good afternoon.
Thank you.